have with us now two representatives of the Environmental Quality Board. They're going to talk about environmental review and the Silica Sand Rule update. This is Erik Dahl, and he is, you're not the director, he's the staff member who's been at the helm for the rule writing process for Minnesota, so particularly related to environmental review. And Kristen Eide-Tollefson, who lives just upriver a few miles, is a citizen board member of the Environmental Quality Board. So, thank you.
Hello.
Oh, it's great to be here, and of course, one of the really important things is that the work that the state has done was in many ways generated by the needs that were articulated by the people of Southeast Minnesota.
Please point that microphone towards your mouth.
Oh, I don't do microphones. Okay.
Thank you.
Okay. Closer? Okay. Anyway, as the subtitle of this suggested, you acted, you came, you acted, you asked, and so much of what has happened has been because of what the questions that you asked. And that process will continue, and the Environmental Quality Board and state agencies encourage you to continue to ask questions. And this is going to be a very quick trip through the environmental review piece and a review of the rules. And we're very lucky to have Erik here. Many of you know him from the rules process, and he's top-notch. And listen up, but don't worry if you don't get it all, because it's both on this sheet, which is here, and it will be up on Katie's website. So thanks a lot.
Thanks, Kristen. Let me know if you can't hear me. I'm not that good with microphones either. Got a lot of things here moving at once. On that round table right here, we've got the tools to assess local government. We only have 3 copies because they're really big and could only print so many, but that's a really helpful document, and it's also available on our website. And if you see this, there's another piece of paper called Resources and Contacts, and that has the link directly to this tools document and a bunch of other documents that I'll be showing you here real quick. As well as it has the contacts for each of the people from the agencies working on the rulemaking for silica sand for the Minnesota Pollution Control Agency, the Department of Natural Resources, EQB, and Department of Health. So their names, their emails, and phone numbers are all on this piece of paper, and they all are I discussed with them this week. They're all totally open to receiving phone calls or emails directly from you on questions regarding the rulemaking or specifics on science or anything like that. Then we have something from the Department of Health on silica sand mining and health, silica sand mining and the environment from the Department of Health. All these are on the round table over there. A couple other quick documents. This one is an example of the petition process, which I'll be talking about in this presentation. And this is a really helpful document in how the petition process works with the EQB and environmental review. And then a community decision-making basics thing that we put together. So I'm Erik Dahl, and I've got a bunch of slides, and it's a really big topic. I'm going to move through it quickly, so if you have questions, feel free to come up to me afterwards or call me directly. My name is on the contact list, or email me. So today I'm going to talk about the creation, objectives, and applicability of environmental review, and then talk about the program elements in environmental review, what the responsible government unit is, what an environmental assessment worksheet is, environmental impact statement, what citizen petitions are for an EAW, and then talk a little bit about mandatory categories and exemptions, and then give you an update on the current silica sand rulemaking, and then talk a little bit about some of the tools for citizens and local governments and stakeholders that I just talked about. Here, a lot of those handouts are some of the tools, but there's many other tools. So, who is the EQB? It is 9 state agencies, Department of Ag, Department of Admin, Minnesota Pollution Control, Department of Commerce, Department of Health, DOT, DNR, Bowser, and DEED, as well as 5 citizen members, and then the Metropolitan Council. And then there's staff that work on environmental review specifically, silica sand. We also work on water issues for the state, long-term planning, climate change, and then just board issues as far as what the board directs us to do. The creation of environmental review. The function of the the EQB, environmental review, is to avoid and minimize damage to Minnesota's environmental resources caused by public and private actions. And the program accomplishes this by requiring certain proposed projects to undergo a special review procedure prior to obtaining approvals and permits otherwise needed. This was established in 1973, and it declares a state policy that will encourage the productive and enjoyable harmony between human beings and the environment. And so, as part of MEPA, the Minnesota Environmental Policy Act, there were statutes set out in 116D, and then rulemaking authority was assigned to the EQB, and the rulemaking is in what we call 4410. That holds what environmental review is, as the mandatory categories for environmental review assessments and EIS. So environmental impact statements. Sorry, I'm trying to go too fast here. So what is environmental review? Environmental review is intended to be used as a source of information for the public and a guide for regulatory decisions. It's to better understand the environmental impacts of a project, provide usable information to stakeholders, the proposer of the project, government decision makers, as well as designate the responsible government unit for the environmental review, as well as reduce delay and uncertainty in the permitting process and the environmental review process. What environmental review is not is it does not approve or deny projects. Do you have a question?
Yes. Could you define a stakeholder?
I don't think I could. I mean, a stakeholder is all Minnesotans, right?
Oh, citizens as well?
Yes, definitely.
Oh.
Yes, definitely. Citizens are an important part of the environmental review process. So when does environmental review apply? This is straight out of the 4410 rules. Environmental review applies when a project means a government action that results which would cause physical manipulation of the environment directly or indirectly. And so what's a government action? A government action means activities including projects that wholly or partially are conducted, permitted, assisted, financed, regulated, or approved by government units, including federal government. Okay, so what's a responsible government unit? A responsible government unit is the entity that carries out the environmental review. So in the 4410 rules, they identify a responsible government unit for each project for mandatory review. And it's normally the government unit that has the most authority over a project. So the RGU, that's the shorthand that we use, makes all the review decisions for the environmental review of what it entails, what the scoping is if it's an EIS, if the EAW is adequate. And the EQB does not do that. We do not make review decisions related to environmental review for a specific project. For the program as a whole, EQB does do that.
But you named the RGU, right?
The RGU is named in rule as part of a rulemaking process. Yeah.
But the EQB can be the RG.
They can, yeah. I'm going to get into that as well. The EQB can be the RGU as part of the petition process or a discretionary review, which I'll get into in a minute here. But the rules provide a hierarchy of selection criteria if the RGU assignment is unclear or if there is a dispute, and really that the EQB board makes that decision if a citizen or a proposer or LGU or RGU brings that before the board and is unclear as to who has the greatest authority or doesn't feel that they have the ability to complete the environmental review effectively. But the EQB has limited authority to change an RGU that is properly designated. They would need to bring that before the EQB board. So who does most of environmental review? Mostly, if we look from our records from 2007 to 2010, mostly it was counties and cities, and then the Minnesota Pollution Control Agency does about 21% of environmental review. Townships do about 6%. This is for the whole state. The DNR does about 4%, and then other local entities do 2%. So when does environmental review not apply? It does not apply when any of the following occur. There's no governmental actions are required, if there's no permits, no financing, that list that I had prior, then environmental review does not apply. If all government decisions have already been made, environmental review can't apply. If approval has already been denied, then environmental review can't apply. If the project is already substantially completed, and this is all defined within our rules in 4410, then environmental review cannot apply. And if environmental review is already completed on a project, it can't be done again. So that's when it doesn't apply. Back again to what environmental review is not. It's not an approval or denial process. A project does not pass or fail environmental review. It also doesn't impose conditions on projects. That's not part of environmental review. That can happen at a local level. It's part of the permitting, but it doesn't, within environmental review, it doesn't impose conditions on a project. It does not give the government unit another or a new authority over another government. I know that this is a lot of information, and I really would totally appreciate it if you gave me a call or emailed me. Okay, so now I'm going to go into some of the program elements associated with environmental review. I'm going to talk about EAWs, EIS, mandatory categories, not really much on exemptions, and then citizen petitions for EAW. So what's an EAW? The purpose is it's a brief document that's prepared in a worksheet format, and they must use the worksheet created by the EQB. It's available on our website. It details out all the aspects that are also put in our rule that went through a rule-making process that involved stakeholders to determine what should be in an EAW. It's for rapid assessment of environmental effects, which may be associated with a proposed project. The rules say EAWs serve primarily as an aid to determine if an EIS is needed. So it's primarily as a scoping document to determine should an EIS occur on a project. It's supposed to be quick, and it's focused on that worksheet. So it serves as a basis to begin the EIS scoping process. So an EAW,
What percentage of EAWs end up with EIS?
I don't have that information, but I could definitely get it to you. I'm sorry, I don't have that off the top of my head.
Do you have to go through an EAW before you get to an EIS, or can you just jump?
You can just jump. If it's a mandatory EIS category, you can go right to
Yeah.
EIS. If it's a mandatory EAW, then you have to do EAW first. If it's a discretionary, you have to also do EAW first.
Thank you.
So EAWs are separate or in different categories. There's the mandatory EAW, and that's within these 4410 rules here, which is a big document that lays out all sorts of different business types or project types that says, specifically for non-metallic mining, if a mine is 40 acres to a mean depth of 10 feet, then you have to do an EAW on it. For silica sand, if it's 20 acres to a mean depth of 10 feet, you have to do an EAW there. So those are some of the mandatory categories. That silica sand example is an interim mandatory category. So, sorry, it gets very complicated.
I thought that a mandatory EAW in the current law comes at 20 acres.
The current interim silica sand rule is at 20 acres, yes. But non-metallic mining, which is a current existing rule within 4410, the interim rules are a legislative, statutory interim rule. They said, for this amount of time, this is what the rule will be, while EQB and DNR and PCR are doing rule.
That's the one that expires in July.
That is correct.
This July?
Yes. We can talk about that more as well. So I just want to make sure I get through the whole thing to get everybody on the same page on environmental review. So an EAW shall also be prepared in the discretionary format. When an RGU determines that a project may have the potential for significant environmental effects, they can say, we want to do an environmental review. So that could be a local government unit, could be part of a petition. Pursuant to a petition, like I said, we've got this document back there that goes through nice bubbles, and then it has a checklist for the petition process for citizens. If it determines the project may have the potential for significant environmental effects, then a discretionary EAW should happen. If the EQB determines a project may have the potential for significant environmental effects, EQB board can order an EAW. If a project proposer wishes to initiate environmental review to determine if a project has the potential for significant environmental effects, they can do that also on their own. So now we're going to get into an EIS, go through kind of some of that. What's the purpose of an EIS? It's to evaluate proposed projects that have the potential for significant environmental effects. Within an EIS, it's to consider alternatives to the project, to explore methods for reducing adverse environmental effects. The contents of an EIS are prescribed in rule, where in the EAW they're just prescribed on the worksheet. But the EIS has a project title, the RGU, the proposer, etc., a description, the purpose, location, size, and phases, the government approvals needed, alternatives, so the alternative sites, alternative technologies that could be used, alternative modified designs, alternative modified scale, mitigation measures, impacts. What are the specific environmental impacts associated with the project? What are the economic? What are the employment? What are sociological impacts of the project? This is specific to EIS. And then what are the specific mitigation measures that the project would need to do to mitigate any impacts that the EIS foresees? Okay, so now back to the petition for an EAW. Anyone can submit a petition for an EAW on a project. And this is a really helpful document, as well as you can always call me or Courtney Ehlers-Nelson, another staff member at EQB, to talk about the
How many
petition.
signatures do you need?
You need 100 signatures of residents or landowners in Minnesota. You need a project description. You need the project proposer. A petitioner's representative contact info so the EQB can talk to somebody about the petition. A description of the potential effects that may result from the project, as specific as possible. And then material evidence indicating there may be potential for significant environmental effects. And if you want to know more about material evidence or potential environmental effects and descriptions of that, there are documents on the EQB website. Look, listed on here. There's just a few of them listed on here because I wanted to keep it one page that you can look at that define those terms, because there's several pages of rule language and interpretation through courts and all sorts of things that get really into detail on what those things are. So what's the petition process? A petition is submitted to the EQB. The EQB determines if the petition is complete, so if it meets all of these 6 things. EQB identifies the RGU. So if it's a mandatory category, and there's, not if there's a mandatory category, excuse me. EQB identifies the government unit that has the most permitting authority over a project and forwards the petition to that government unit. And then at that point, the RGU decides if the EAW should be prepared, not the EQB, unless the EQB is the RGU. So the rules indicate. Now I'm going to go back to mandatory categories, unless someone has questions on the petition process. I'm sure there's lots of questions.
It's a little off, but when the rules in the tools document run out in July 1st, before the new rules are made into law, is that what the process, the petition process, is that what we have to use if somebody tries to?
That could be one avenue for doing the review of an environmental review or doing of a project.
Asking for
but just so it's clear, so in the tools document, the rules are referenced in there, but the tools document is not the rule or not the interim rules.
Right.
But
when we'll have a sort of hiatus where there's no rules.
well, there will still be non-metallic mining rules during that time period that are currently mandatory categories 4410. 4300 subpart 9 that is for non-metallic mining for the EAW, and then subpart 4410, 4400, subpart 11, I believe, is for EIS.
I will note that question down, because that is a good question.
So in essence, citizens are losing a lot of protection in this interim period.
Can you repeat the question, please?
She asked if citizens are losing a lot of protection in this period. And I would say that there are, the interim rules will expire on July 2015, but there's still always the discretionary means at that time for RGUs, citizens, EQB, proposers to complete environmental review.
So what's the time frame? Isn't it very short?
What's that?
The time frame for
Time frame.
submitting the decision
Repeat the question, please.
what is the time frame for submitting a question or petition process? And that's a good question. That I'm-
Pretty fast.
Okay, yeah. I will note that one down. too.
Okay.
Yeah. We'll get this all to Kate.
Okay, so I'm going to go back to the mandatory categories. Mandatory categories, rules include categories for types of projects in mandatory categories. There's EAW categories and EIS categories. And category establishes a threshold. So when a project exceeds a threshold, an EAW or EIS is mandatory. So for silica sand currently, if a silica sand project excavates 20 or more acres of land to a mean depth of 10 feet, then the LGU is the RGU. If it has a throughput of 200,000 tons or a storage pile of 7,500 tons, then the MPCA is the RGU. So there's the threshold of, excuse me, too many documents. There's a threshold of 20 acres and mean depth of 10 feet, and another threshold of 200,000 tons and 7,500 tons. And then there's the RGU. So that's what the mandatory categories establish is the threshold and then the responsible government unit.
So Eric, are those thresholds in place even after July 1st?
For the interim rules, they're not. Per the legislative directive, those expire July 1st, 2015.
Right.
So the legislature set those interim rules, and that's the time frame.
I guess our question is, what if on July 2nd, somebody tries to go over and say the 200 tons, whatever, then what do we do?
I think that there's those discretionary means for doing environmental review. There's the petition process. There's the RGU can order environmental review because they're, EQB is, I'm going to go through these in a minute, but EQB is working on rules that are out there in the public. And there's intent behind those. They aren't current or aren't finalized or formalized rules yet, but there's some intent behind those. So maybe if a project is there, then RGU could say, well, there's intent and there should be discretionary RGU or discretionary review. Does that help?
Thank you.
Yep. Okay. So now I'm going to get into a few more of the weeds here. Mandatory categories. When you look at a project, thresholds, you also need to look at phased and connected action, which I'm going to get into what those are. And then look at the EAW, for an EAW, look at construction that has occurred in the last 3 years, which we call the 3-year look-back rule. So how has construction been, or has the project been constructed within the last 3 years? And then that should be added on to the current new proposed project construction amount. So what's a phased action? A phased action is a project that meets all of these following criteria, which is going to be different than connected action, which I'm going to talk about in a minute, which can meet any of the criteria. So for phased, it's meeting all. And this is in the tool document as well as on several of the documents that I put on that list of resources. It has to meet all the same. It has to be the same proposer. So if it's a mine, the same owner, or just the same proposer. The has to have environmental effects in the same geographic area. And that is, there's a lot of documentation on what the same geographic area is, and if you want to get into that, we can chat more about that after. It has to be substantially certain to be undertaken sequentially over a limited period of time. So, and that is also discussed in detail in a lot of our documents about what limited period of time means and what means sequentially and that sort of thing. So here's an example of phased action. You have mine company X that also owns processing company X. It's the same proposer, they're in the same geographic area, and they are sequentially over a limited period of time. So then that means that you need to do environmental review and look at them both. Connected action. Connected action means projects related in any of the following ways. these. Where the other one has to be all three, this can be just any one of these. One would directly induce the other. One is a prerequisite for the other, and the prerequisite project is not justified by itself. And that neither is justified by itself. So if any of those, then it's a connected action. And then you want to be looking at this as you're looking at should a project undergo environmental review for mandatory or discretionary. So here we go, we've got mine company X and processing company Y. So you do two different companies, but potentially mine company X induces processing company Y because they need to process what they're mining. Or mine company is a prerequisite to processing company Y. You can't have a processing company if you don't have a mining company. And that neither is justified on its own, then you'd want to do environmental review. So now I'm going to talk about the most complicated one, cumulative potential effects. And this occurs within environmental review. And I just have a graphic on this, and there's a lot more detail on this, but cumulative potential effects is studied within environmental review, where the other two you look at before you do environmental review. So that's really key. Those you look at before, because you're looking at, is this project a phased project or a connected project to other projects? Where this one you're looking at, what are the cumulative potential effects of multiple projects? And they may not be related in any way. So for instance here, we've got mine company X, separate processing company Y, and then ballpark. A ballpark's going through an EIS. All three of these have increased traffic. And within environmental review, you need to account for all the increased traffic that each of these separate companies, how it interacts. You know, that ballparks, they start the game at 7, processing companies operating at this time, mine companies operating at this time, and the traffic is all interacting with each other, and there's potential for environmental impacts there, or cultural impacts, those sorts of things. So that one's really confusing, and if you have more questions on that, we can definitely go into more detail. Feel free to call me. Okay, so now I'm just going to give a quick update on the rule. So as part of the 2013 legislation, the EQB was told to amend environmental review rules for silica sand mining and processing due to increased activity in the state based on project size and project location. Somehow I lost my PowerPoint here. So I want to make sure I cover everything on this. And let me know if I'm taking too much time, but I want to make sure you guys get the update on this. So we're looking at, for the rulemaking, that we need to look at things based on the size and concerns over size and of specific operations, but also look at different geographic areas of the state. And so that's what we're working on currently. There are 3 agencies working on rulemaking. There's the Pollution Control Agency, which was told to adopt rules pertaining to the control of particulate emissions for silica sand projects. TNR is working on rules pertaining to the reclamation of silica sand mines. And then EQB, that's me, and the EQB board shall amend its rules for environmental review for silica sand mining and processing to take into account the increased activity in the state and concerns over size of specific operations. So I'm only working on rules for environmental review for silica sand, determining what should the rules be, what should the thresholds be, who should be the RGU. That's what EQB is working on, where pollution control is setting the applicability and limits of particulate emissions, and the DNR is working on what should the reclamation plans look like from a state perspective on silica sand mines. So I've talked about it a little bit before. We've got this interim rule. It has 2 parts, multiple parts, but 2 parts that really separate it. We've got any mine that excavates 20 or more acres of land, or actually any project that excavates 20 or more acres of land to a mean depth of 10 feet or more during its existence, the local government is a responsible government unit. The projects that's designed to store or capable of storing more than 7,500 tons of silica sand and has an annual throughput, or has an annual throughput of more than 200,000 tons of silica sand, and is not required to have a permit from the Pollution Control Agency. In that case, the Pollution Control Agency is the responsible government unit. So that's the first part, though, that's the thresholds and the RGU. And then the second part is really something that is more requirements of an EAW form, an EAW worksheet of what I talked about before. When you do an EAW, you have to complete a worksheet. And these requirements are already included in the EAW now from the EQB board. And I wasn't going to really go through them, I can just briefly talk about them, but they're not part of the rulemaking. They're not something that you put in in 4410 rules. In 4410 rules, you put in thresholds and RGUs. That's it. So, take a drink of water.
Eric, the EAW, the facilities, that form is not going to change in July.
No, that form does not change on July 1st. So this second portion is that every project has to undergo a hydrogeologic investigation. So this is on that EAW worksheet for assessing potential groundwater and surface water effects and geological conditions that could increase the risk of potentially significant effects on groundwater and surface water. Every project in the EAW form with the potential to require a groundwater appropriation permit from the Commissioner of Natural Resources, there needs to be an assessment of the water resources available for appropriation. An air quality impact assessment that includes an assessment of the potential effects from airborne particles and dust. So that has to occur in the EAW specific for silica sand projects. And as Kristen said, this continues after July 1st. This continues until an EAW form is changed by the EQB. A traffic impact analysis, including documentation of existing transportation systems, analysis of the potential effects of the project on transportation, and mitigation measures to eliminate or minimize adverse impacts. And an assessment on the compatibility of the project with other existing uses. So that's kind of the cumulative potential effects, but there's another portion of the EAW form that talks about cumulative potential effects. And then mitigation measures that could eliminate or minimize any adverse environmental effects of the project. So those all have to be included on the EAW form, and that continues after July 1st. So EQB went through or is continuing to go through a stakeholder process in developing the new mandatory rules for silica sand projects. We put out a request for comments in July 2013. We visited 18 LGUs. We held the Silica Sand Rule Advisory Panel, which a lot of people here were part of, and we really, really appreciated that. That met for over a year and was incredibly helpful, as I'll talk about in a minute here, of how we develop rules with the EQB. So we visited silica sand projects in Minnesota and Wisconsin. We had face-to-face meetings with many stakeholders. And we did an online survey of LGUs about draft rule thresholds. And then we talked to state technical experts from the DNR, PCA, Department of Health, any experts that had anything to do with mining or processing, Department of Transportation. So what goes into an environmental review, EQB rule, threshold, and RGU development? What's different than the PCA and the DNR is that the EQB is not, we focus on data and science for the mines processing any silica sand projects. We focus on the historical context. So what are the silica sand projects in Minnesota? And then we look at stakeholder input. And the stakeholder input is extremely important. That's citizens, LGU, industry, and agencies. And that, it's like a three-legged stool. They have equal value there. And that's, if we look back at how all the mandatory categories were set up, that's how they were set up.
As part of the science of setting the threshold, would you consider setting a separate set of thresholds for the karst area of the state?
We are still considering that right now. And I think if you would like to write us with your specific comments on that, that is very helpful still. You can call me directly. We're still not in an official comment period. We're still in the preliminary period of rulemaking, and any comments from stakeholders or meetings with citizens, agencies, industry experts, we're open to all that and would love to talk to you more about that. What's difficult about karst is that it's Karst is a difficult thing to tell if it's karst or not karst, and that's what we're struggling with currently.
The tools booklet has some information on it, though,
Definitely does, and we're definitely.
but follow the tool.
Eric, did you attend with Heather Ahrens down at the Houston County Commissioning Room last year?
I've
brought 'em up to
been
date?
to Houston County, yes. Yep.
When you were there, I talked with Heather for a couple minutes before and after your presentation to the board, which is very good, by the way.
Thank you.
And I asked Heather, I said, so where does the 40 acre and where does the 20 acre threshold, where do those figures come from? She said, from hard rock mining in northern Minnesota and the Iron Range. I said, that has nothing to do with karst.
Yep.
I do believe that 20 acres is too damn much.
Okay.
We need a lower threshold.
Okay.
Really?
Yes.
Amen.
But that's again why it's important that we have the stakeholder input is an important part, an important leg of the stool when we look at it as a three-legged stool of data and science, the historical context. So like what projects are we seeing in Minnesota? And we looked at Wisconsin as well, and then stakeholder input. So so I'm really at the end here. So I know that I'm done. I'm sorry, I tried to go fast.
90 seconds.
So the next steps is we're still working on the rule language. We're still working on the sonar, which I didn't really talk about, but when you make a rule in the state of Minnesota, you develop a thing called a statement of need and reasonableness, and you have to explain to an administrative law judge and the public why every rule is needed and why it is reasonable. And those are specific legal terms that there's a lot of documentation on. So what we'll be doing with the EQB is we're working on that still. Then we're going to transition to official rulemaking this summer. We're going to go to official rulemaking, we have to go back to the EQB board for approval of the rule language and the sonar. So there's another opportunity for the citizens to comment at that time to the EQB board. And then once the board approves it, then we'll notice the proposed rule and notice a hearing. And at that point that we notice that, the sonar and the rules will be out there and we can take comment on those from stakeholders and we respond to those comments. And then there will be an ALJ hearing, which is an administrative law judge hearing, which we present the sonar and the rules, and there's another opportunity there for stakeholders to comment. And then the administrative law judge reviews and reports back to us on is the rule needed and is it reasonable? And then we have to respond and determine which of those things we accept that they aren't needed or reasonable and which we're fighting with. And then the EQB reviews and adopts that, and then the governor has a veto period, and then we publish the notice of adoption. So what I'm saying is there's many more opportunities for the public to still be involved, and trust me that it's been very helpful with the rule panel as well as just citizens and stakeholders giving their feedback on the rules to help us really find the needed and reasonable rule. So there's a bunch of tools that you already have. There's an ordinance library online that can be helpful for local governments or planning commissions or stakeholders. It helps you sort every ordinance in Minnesota for silica sand mining or non-metallic mining. You can look at, who has dust control, who has financial assurance, who has groundwater standards, and then a link to it, and you can sort it all, and it's really great and helpful. Then we also have the Silica Sand Technical Assistance Team, which is something that the legislature gave EQB money for to directly help responsible government units, LGUs, in silica sand projects. And that can be called on officially, or it can be unofficially just LGUs asking questions if they need help. And so that's that right now. Sorry that I talked so fast.
Sure, download your toolkit, the toolkit.
Yeah, you can download the toolkit. And you can find rulemaking here at eqbstate.mn.us. That's all right on your resources sheet.